Okay. Thank you so much for joining me. My name is Melissa Kuczynski, for those of you who don't know me. If you don't know me, I hope I get to meet you soon and hopefully in person when it's safe. Today, I am going to provide a rapid fire summary of the top international family law updates for 2020. I am going to do my very best to fit it into this 1 hour luncheon type block of time. If I tend to run a bit over, I am recording this. I'm going to put it up on my law firm's YouTube page, and then I have a lawyer research on resource page that I'm going to put it up on as well so that everyone can access it. So let's see if I can get started here. This is the lawyer research page that I have for the information that I've been sharing with attorneys. It has legal updates that I've been gleaning for my blog and for the Year in Review article that I co-author with Professor Robert Spector, links to the court opinions, links to websites that might be useful for international family law. So please feel free to access that, and I'll put it up again at the end of the webinar. So let's get started. As many of you know, the HAGUE Conference on Private International Law is an international organization. It's located in The Hague, Netherlands. It's the primary proponent of international family law treaties. And with 85 member states and the European Union, it is staffed through its secretariat called the Permanent Bureau. It provides support to explore and negotiate new international treaties in the field of private international law, and it provides post-convention support. Its governing body, the Council on General Affairs and Policy, will be meeting the first week of March. I'm not sure if it will be in person or remote, hopefully remote. Its agenda will include the work of its experts group on parentage and surrogacy, and planning for the 8th Special Commission meeting on the Child Abduction and Child Protection Conventions, among a variety of other topics. It anticipates it may hold its 8th Special Commission meeting on the Child Abduction and Child Protection Conventions in 2023. It is preliminarily exploring possible topics to include on its agenda, including the interpretation of habitual residence, which we'll get to today, hearing the child's voice, good practices for addressing delays in abduction proceedings, remote hearings, guardian ad litems, and family relocation, among other things. So very interesting potential agenda. The Child Support Convention Special Commission was scheduled for last month, December 2020, but it's been rescheduled because of COVID. It has a tentative in-person date for this summer in The Hague, and we'll see if that proceeds. Earlier in 2020, the Hague Conference did finalize its Guide to Good Practice on Article 13B, which is the grave risk of harm exception to returning a child under the Child Abduction Convention, and it produced a COVID toolkit pinpointing resources on its website for the Hague Child Abduction Convention vis-a-vis this pandemic that we've been experiencing. And on October 25th of 2020, the Hague Child Abduction Convention celebrated its 40th anniversary. Now turning to the United States, the U.S. Department of State issues a yearly compliance report as mandated by Congress that reviews outstanding child abduction cases from the United States to other countries and explores some of the underlying reasons why these cases continue to remain unresolved. The report includes both countries where the treaty is in place, the Hague Abduction Treaty between the United States and the other country, and countries where there is no treaty or other legal relationship in place related to child abduction or the movement of children. For the 2020 report, which looks at cases from 2019, there were several countries designated as non-compliant by the United States. The full report can be found on on the State Department's website, which is on the slide. It can also be found by going to my lawyer resource site. Non-compliance actually relates to a country's persistent failure to abide by legal obligations to return children or work with the U.S. government to resolve cases. Under the International Child Abduction Prevention and Return Act of 2014, a persistent failure is where 1, 30% or more of all abduction cases remain unresolved. 2, the foreign country's government fails to fulfill its obligations under the Hague Abduction Convention or bilateral agreements. 3, the judicial or administrative branch fails to implement and comply with the Hague Abduction Convention or bilateral agreements. Or number 4, law enforcement regularly fails to enforce return or access orders. Many of the rest of today's updates will revolve around the Hague Abduction Convention. So the first update, of course, is that there is a new treaty relationship between the United States and Pakistan. On July 1st, we accepted Pakistan's accession to the Hague Abduction Convention. The treaty then entered into force between the United States and Pakistan on October 1st, 2020. Pakistan became a party to the 1980 convention in 2017, but the US delayed in accepting its accession. Pakistan has not completed its country profile, which is a document requested of each country who becomes a treaty party to the convention. The country profiles are very helpful documents. They're maintained by the Hague Conference on Private International Law, and it gives basic details of the treaty's operation in a particular country. So we'll be waiting for Pakistan to complete that. Now, as a reminder, the Hague Abduction Convention only applies to children under the age of 16. On October 29th, the California Court of Appeal addressed this in an unpublished opinion. It was a second appeal by Tammy Noergaard to the order that ordered her return of her eldest daughter, Mia, to Denmark. Tammy has 2 daughters with Christian Noergaard. Christian has full custody of both of the daughters under a Danish custody order. In May of 2013, Tammy abducted the oldest child, Mia, to California. In January of 2014, Christian filed a Hague abduction return petition, and Mia was ordered returned to him. The return order was executed, and Mia actually did return to Denmark. Tammy appealed. That was her first appeal, and her case was reversed and remanded for a new trial because of some due process deficiencies at the first trial. After the second trial, the court again ordered Mia returned to Denmark, but of course she was already living there at the time. Shortly after the second return order, Mia turned age 16. Tammy then appealed the second return order. Her notice of appeal was filed after Mia turned age 16, even though the return order was entered before Mia turned age 16. Citing to a State Department publication, the court said, even if the child is under 16 at the time of the wrongful removal or retention, as well as when the convention is invoked, the convention ceases to apply when the child reaches 16. The court therefore concluded that at Mia's 16th birthday, the Hague Convention no longer applied to her. In other words, the court said, even if the trial court had erred somewhere in the Hague proceeding, the appellate court was powerless to provide any effective relief from the return order on that appeal. So now we're going to return to the biggest issue, the habitual residence case that came down out of the US Supreme Court. It was authored, the opinion, by the late Ruth Bader Ginsburg. On February 25th of 2020, the US Supreme Court concluded that a child's habitual residence is a flexible fact-bound determination that should focus on the place where a child is at home at the time of the removal or retention. The standard gives a trial judge significant deference. The Supreme Court gave little guidance on how best to weigh the different facts that will inevitably be presented to the trial judge, and left that to the discretion of the judge, with the view that no single fact is dispositive across all cases. The court also held that the question of a child's habitual residence is a mixed question of law and fact, but only barely so. And with the legal standard now clear, the court is left with a completely factual analysis when determining a child's habitual residence. Therefore, on appeal, the appropriate standard for habitual residence is clear error. Because of COVID, we've only just recently begun seeing opinions that are applying this new Manaski standard. Some courts are actually choosing to distinguish Manaski and not apply it, continuing to apply their old standard. On August 20th, for instance, the Ninth Circuit addressed this issue in Farr versus Kendrick, concluding that the United States and not Mexico was the children's habitual residence, and therefore they cannot be returned to Mexico. The trial was actually held before Manaski was handed down, so the trial judge applied the existing standard in the Ninth Circuit, looking at the parents' shared intent. On appeal, the Ninth Circuit concluded that the trial court gathered sufficient evidence that the Ninth Circuit, was able to conclude that the U.S. is the habitual residence after applying the Manaski opinion. For example, some of the facts that the trial court elicited was that the dad's job was temporary in Mexico, and the mom and the children had temporary visas that had expired. There was a December 2016 email where the dad was detailing a plan of action to return to the US and select the city where they would ultimately reside in the US. And there were some March 2016 texts where the mother expressed uncertainty about the family's living situation, not knowing whether the family would continue living in Mexico on a month-to-month basis. 5 days later, the U.S. District Court for the District of Minnesota ordered a child returned to Germany in the case of Forcelli versus Smith. The key issue again was habitual residence. In this case, in or about August of 2019, the parents agreed to have their 3 children visit with the father in Minnesota for a sum total of 3 weeks. Just prior to the trip, the parties started talking about the mother securing a green card and completing that process, but she never ultimately did. The oldest child was already a US citizen. The parents had applied for citizenship for both younger children. And when the mother and the 3 children arrived in Minnesota, the mother expressed concerns over her finances and her health. So the parents agreed the 3 children would remain with the father in the United States. And the mother says the agreement was for, quote unquote, the time being. She then returned to Germany on September 6th of 2019. During that month of September, she was actually hospitalized twice in Germany. The parents enrolled their children in school in Minnesota, and the mother notified the German school that they would be in the US for the time being. The mother also contacted the German municipality to notify them that children would be in the United States temporarily, and she did not wish to deregister them from that municipality. But throughout this, of course, the father believed the entire family was actually going to relocate permanently to Minnesota and that the parents were going to attempt to reconcile. In late September of 2019, the mother told him that that was not going to happen. So on November 17th of 29, the parents had an angry exchange, and the father told the mother that he was never to come to her home again or he would call the police. The mother pinpointed this as the date he began retaining the children. She called the Minnesota police and the German consulate. And in December of that year, she traveled to Minnesota with the intention of returning the children. The 2 older children actually returned with her. The youngest refused, which is the youngest was the party to this particular Hague abduction return petition. In applying Manaski, the court concluded that the mother did not intend to abandon Germany as the children's habitual residence, and therefore it remained their habitual residence. In 2020, the Fifth Circuit also had the opportunity to apply Manaski in Smith versus Smith. The parents and children, all US citizens, were residing in Argentina when the mother traveled with the children to Texas for a funeral and then retained them in Texas. The couple shared custody in an Argentinian custody order. The children's mother argued that the United States, not Argentina, where it was their habitual residence, and she prevailed. At the time of the trial, Manaski had not been handed down yet, so the district court applied the parents' last shared intent, but in doing so, it did examine all the facts in the family's history, including the father's work contract, which was at will, and contained provisions for home leave referring to the United States, and that the Argentinian custody order referred to the children having permission to travel to their quote unquote country of origin and had no provisions requiring any person to live exclusively in Argentina. Ultimately, the Fifth Circuit concluded that the US District Court had examined all of the facts. The Fifth Circuit found no clear error with the District Court's factual examination, and therefore the Fifth Circuit applied Manaski and concluded Argentina was not the habitual residence. And it followed the example of Manaski and did not remand the case, saying that would be too time consuming for a swift resolution, and there was no evidence that the district court would view the facts differently if it had remanded. On August 26th, the U.S. District Court for the Middle District of North Carolina, in the case of Chambers versus Russell, ordered the return of a minor child to Jamaica. which was his habitual residence. This case was interesting because the US District Court distinguished Manaski and elected to apply its prior approach, which involved looking at the parent's shared intent and whether there was an actual change in geography for an appreciable period of time for the child to acclimatize. In this case, the child was born in and lived in Jamaica his entire life. His parents had an informal custody agreement. His father then moved to the United States, and his mother found a job in the United Kingdom, and she was in the process of moving there. But they agreed that the child would remain in Jamaica living with some family before he would then go to the UK with the mother. The father, when he had the child in North Carolina for summer vacation, retained him at the end of that break. The North Carolina court applied its prior two-pronged approach. It concluded that the parents never abandoned their intent for the child to reside in Jamaica. The fact that they had a future desire for the child to move to the UK was irrelevant. It was their intent that the child be in Jamaica, live there, and attend school there at the time of the retention that was the deciding factor. Whether for the child being acclimatized, the court did look at all of the child's school activities, length of stay, family in Jamaica. The court was not bothered by the fact that the mother had taken up residence in the UK on a temporary work visa, acknowledging that she was not likely to move to the UK permanently unless the child was actually with her. So there were two cases last year that specifically dealt with the issue of child's habitual residence when the child that was being asked to be returned had actually never resided in the country where the child would be returned to. The 10th Circuit affirmed the decision of the trial court in Pope v. Lundy. Ms. Lundy, pregnant with twins, returned to her home of Oklahoma from Brazil. The twins were born in Oklahoma, and shortly thereafter, Mr. Pope filed suit seeking their return to Brazil. The children had never been to Brazil except in utero. The trial court focused on pinpointing their habitual residence. It concluded the United States, and therefore denied Mr. Pope's return request on the papers without a trial. Mr. Pope argued that the parents shared an intent to make Brazil the home of the twins, that Ms. Lundy had actually taken steps towards becoming licensed in her profession in Brazil. They registered their partnership in Brazil, but the court said Manaski does not require the court to focus on last shared intent. It gives the judge broad discretion to consider everything that's relevant. So Ms. Lundy argued that the children had never stepped foot in Brazil, but the court also said Manaski doesn't say that an infant's physical presence is a dispositive factor. The 10th Circuit concluded that the district court's ruling was consistent with the totality of the circumstances analysis, and the trial judge considered a wide range of factors from birth, citizenship, duration of residence, etc. So compare this case with De Carvalho versus Carvalho Pereira. And I apologize for any mispronunciations. The District Court of Appeal of Florida, the state court, affirmed the trial court's order of 2 children to Brazil. The family in this case moved to Florida in January of 2016 for the father to take a short-term medical fellowship in a US hospital and for the mother to give birth to their second child on US soil. A few months later, and after the child's second child's birth, the father's fellowship fell through. He returned to Brazil. He started preparing their home for everyone's return. He sent plane tickets to his family, but the mother, on or about April 5th of 2016, decided she was not going to come back with the children. She was remaining in the United States and wished to divorce. The trial court concluded that neither parent intended to permanently relocate the family to the US until about April 2016, when the mother unilaterally decided to remain. So the trial court concluded Brazil was the children's habitual residence, even though at the time that they were proceeding to trial, the oldest had not lived there for 4 years, and the youngest had never lived there. The appellate court refused to overturn that decision, citing the deference given to the trial court by the Manaski clear error standard of review. The initial analysis of habitual residence requires pinpointing that date on which a child was wrongfully removed or retained. It's not always clear, and it requires some strategy by the lawyer that's handling the case. So on April 23rd, the U.S. District Court for the Western District of Michigan issued an opinion on remand from the Sixth Circuit in the case of Moreno v. Zenk. It wanted to pinpoint the moment in time when the minor child was wrongfully retained by her father in Michigan. While the family had an acrimonious history, the court chose to focus on several dates within the month of August 2016 to try to pinpoint the date on which the minor child, BLZ, was retained in Michigan at the end of a summer vacation. Apparently, the father was slated to put her on a plane to Florida on August 9th, where the maternal grandfather would meet her in Florida. But due to a Delta Airlines nationwide outage, that flight never happened. Shortly thereafter, missing her flight, the child told her father that she objected to returning to Ecuador. The minor child's travel authorization permitted her to be in the US until August 15th of that year, probably because she was going to go to Walt Disney World with her grandparents. The respondent father filed for a change in custody actually on August 10th in Michigan, but that action was actually never served on the petitioner mother. The respondent father called the petitioner mother when the child did not get on the flight to Orlando, but he didn't specifically say he was going to keep the child in Michigan. All these dates are important, of course, because the mother did not file her Hague return lawsuit until August 14th of 2017, and the court needs to pinpoint precisely the date of the retention because if the mother had filed in excess of 1 year, then the father could argue that the child was now settled in Michigan. So the court concluded it needed to examine the dates on which the retaining parent's actions were so unequivocal that the left behind parent knew or should have known that the minor child would not be returned. It analyzed all the evidence, it weighed the credibility of witnesses. It started with the August 15th date. It worked backwards. It looked at the petitioner, the mother's actions that could cause the court to believe she knew or should have known the child was not coming back. And it pinpointed the date of wrongful retention as August 11th, which is 24 hours after the mother had called the father to find out where the daughter was, and he didn't return her call. Her petition was not timely filed within that 1 year, so the father could argue that the child was then settled. So that does bring us to the now settled exception to returning a child. That pinpointing that date is crucial in so many ways, most prominently when a respondent might be permitted to argue that the petitioner commenced the proceeding more than 1 year beyond the wrongful retention or removal. On August 26th, in the case of Zerol versus Mesa, the U.S. District Court for the Southern District of Texas ordered the return of a 15-year-old to Venezuela. The party's youngest child was the subject of a Venezuelan custody order. It gave both parents joint parental responsibility. It ordered the mother, who was the primary residential custodian, to not unilaterally change the child's residence without the father's input. She asked the father's permission to take the child to Houston in summer of 2018. He refused. She then sought court permission to allow her to travel. The court granted that permission, but required her to appear in court the week after her scheduled return. And of course, she didn't return. A taking parent is permitted to argue that a child is now settled in his or her new country if the left behind parent commenced the return proceedings more than 1 year after the child's wrongful removal or retention. The prevailing view is that the U.S. federal implementing legislation, ICARA, the International Child Abduction Remedies Act, says that a proceeding is only commenced with the filing of a proper lawsuit in the state or federal court where the child is now sitting post-abduction. In this particular case, the father lodged an application for the return of his child on November 11th with the Venezuelan government, the central authority, which then transmitted that application to the U.S. Central Authority, the Department of State, on December 26th. The father also pursued criminal charges in Venezuelan courts, but he did not file his Hague return lawsuit in Texas until after 1 year had passed. Now, Texas, despite the prevailing view and the plain reading of ICARA, concluded that Article 12 of the Hague Abduction Convention only requires a parent to submit their application to the proper administrative authority, i.e. central authority, to initiate their return request within 1 year. And the father in this case did just that. So they did not follow ICARA in this particular case. And compare that to Castro versus Hernandez Renteria, where the Ninth Circuit also addressed the now settled exception, affirming the trial court's refusal to return a minor child to Mexico because the petitioner filed his lawsuit more than 1 year after the retention or removal. The facts in this case are actually extremely convoluted, but it boiled down to some very creative arguing over the precise date of that removal or retention. The court looked at a variety of dates and ultimately chose a date and concluded that the petitioner had filed in court beyond 1 year. And then the court could assess whether the child was now settled. This just goes to stress that the US implementing legislation says that you have to commence a Hague proceeding by filing a lawsuit in the United States. That's not necessarily the case in other countries. It is insufficient to only file an application with the foreign or US central authority. So be certain that you follow that procedure. When actually assessing whether a child is now settled, it actually helps to understand what a court is going to look at. The case of Beijar versus Jimenez denied a petitioner father's request to return his child to Honduras using the Hague Abduction Convention. The court concluded that the petitioner filed his return petition in the appropriate federal court 16 months after the child was wrongfully removed. The court looked at several factors, which included the child's age, the child's stability in the new residence, whether they attended school or daycare consistently, whether they attended church regularly, the parents' employment in that new jurisdiction and its stability and their means of supporting the child, whether the child has friends and relatives in the area, to what extent the child maintained ties to his or her habitual residence, the level of the parents' involvement in the child's life, active measures to conceal the child's whereabouts, and also the immigration status of the child. The court weighed all of those factors here and found that an overwhelming number of them weighed in favor of the child being now settled in New Jersey. And since there was no immediate threat of deportation because the mother and the child lacked status, the court decided not to give that determinative weight. So while it's a factor, it wasn't a determining factor. Turning to another exception, the case of a mature child objecting to his or her return. In the case of Cologne versus Montefiore, the US District Court denied the father's request to return his minor child to Guatemala. The court concluded that the mother met her burden, that the child is of sufficient age and maturity, and that the court should consider his objection to being returned to Guatemala. The mother actually hired an expert, a psychologist, to testify that the minor child was mature enough to independently form and state an opinion as to whether he objects to a return to Guatemala, and that the child's opinion does not appear to have been the product of coercion, coaching, or parental alienation. Ultimately, this child objected to returning because he feared reprisals from gang members in Guatemala. He preferred to remain with the respondent in the United States, and he perceived better opportunities for himself in the US over Guatemala. The father actually presented no evidence that contradicted the particular expert's findings in this case. The US District Court in New Jersey ordered 2 children returned to El Salvador on October 30th of last year. The eldest child was age 15 and apparently stated a preference for the United States. The court actually seemed to take notice of this preference, but used its discretion to nonetheless return the child, or both children actually. What's most interesting in this case is that apparently there was a request by counsel for the court to interview the 15-year-old. And the court declined, saying, this court declined to hear testimony from the children at the October 20th evidentiary hearing, as it would have been redundant, needlessly harmful to the children, and potentially influenced by the respondent. Looking at fees in Hague abduction suits, the U.S. District Court for the District of New Jersey in Stone versus Stone reaffirmed that a prevailing respondent, the taking parent, in a Hague abduction return proceeding is not entitled to an award of fees. Specifically, the implementing legislation, ICARA, requires the respondent to pay necessary expenses if the petitioner prevails. There is no provision under which a respondent may recover fees and costs from a petitioner. So everyone has been asking the impact of COVID-19 on these particular child abduction cases, specifically under the Hague Abduction Convention. As the pandemic drags on, it's inevitable that we're going to continue seeing some of these cases and how they address this issue. In the case of Sochi versus Durvishy, the California District Court ordered 2 children returned to their habitual residence of Italy and crafted its return order to account for the European Union's travel restrictions at the time that left the US off of approved travel partners because of a resurgence of COVID in many parts of the US. The court order specifically said if travel is allowed due to COVID, Durvishy shall return the children to Milan, Italy within 14 days. If Italy is not allowing flights in from the United States, then Durvishy shall return the children within 14 days of any travel restrictions being lifted. In Guerra versus Rodas, the plaintiff mother sought the return of her minor children to Guatemala. The court ultimately ordered the minor child returned to that country, but further addressed the fact that travel into Guatemala was apparently banned at the time because of COVID-19. The parties consented to staying the return order until the travel ban was lifted and international travel was no longer deemed unsafe due to the pandemic. The plaintiff's counsel was ordered to notify the court immediately upon the lifting of the travel ban, and the parties were ordered to provide joint status updates on the 3rd day of each month. The court kept in place a restraining order, keeping the minor child within that district until he was returned. On April 30th, the U.S. District Court for the Western District of Texas issued an order in the case of Gallegos versus Garcia Soto, returning the party's minor child to Mexico. The court, which took evidence in early March, took the further step of staying its return order because of COVID-19. Most interestingly, the court stated, however, it is further ordered that the effective date of this order is stayed indefinitely until such time as the court and the parties can be reasonably confident that the COVID-19 pandemic no longer renders international travel unsafe. So there's very broad language in that particular order. So now we get to another issue that has been flaring up over the past year during the pandemic, and that's the issue of abstention. In other words, when a federal and a state case are simultaneously filed. In June 23rd, the opinion in Cordoba v. Mullins raises a really interesting abstention issue because there was a state court divorce and protection order matter and a federal Hague abduction return petition. So not identical legal actions. Ms. Mullins allegedly absconded with the party's 2 minor children to Illinois on January 4th of last year. On January 9th, she filed a dissolution petition in a civil protective order matter in the Cook County, Illinois Circuit Court. On March 18th, Mr. Cordoba filed a motion to dismiss the state action, arguing a lack of jurisdiction. The motion itself, according to the federal court, first raised the issue of the Hague Abduction Convention. It was not a return petition. It was not a request filed under the Hague Abduction Convention in the state court. But at the time of the motion, Mr. Cordoba had not filed any court action in the US actually requesting the return of his children using this particular treaty. In the state action, Ms. Mullins had filed a motion for declaratory judgment. She argued that Ecuador is not the children's habitual residence and that if it were, it would be a grave risk to return them. She asked for a judgment to declare the rights of the parties with regard to Mr. Cordoba's request to have the children returned to Ecuador. These arguments are tantamount or close to what she might have argued in a Hague abduction suit. 4 days later, that's when Mr. Cordoba filed his Hague return petition in the federal court. Ms. Mullins then sought to dismiss or stay it based on the abstention doctrine. The federal court agreed. It stayed but did not dismiss the case. The federal court concluded that the parties were the same, the issues arose out of the same facts, and similar legal issues were raised by the parties in the parallel state action. The federal court decided that the state action would dispose of the claims presented in the federal case and that the cases need not be identical. Compare this case to another abstention case in California, the Barron v. Kendall case. In this case, the father allegedly abducted the party's 5-year-old child from Mexico to San Diego, where about 1 week later, he then filed for custody. He was granted temporary emergency custody. The mother appeared in the custody case in February of 2020. She requested the family court return the child to Mexico. This was not an actual filing under the Hague Abduction Convention. The judge denied the request, but sua sponte, on his or her own accord, set in the case for a Hague status hearing, despite the fact that no petition had been filed under the treaty in the state court. At the status hearing, the judge actually set in a trial date on the Hague abduction issue, but it was continued due to COVID. So in April of 2020, a few months after the initiation of the family court case, the mother filed a Hague abduction return proceeding in the companion federal court. She requested the child's return and for the federal court to vacate the San Diego family court's temporary custody order. The Hague proceeding in the state court was still pending, and the federal court abstained based on the pending Hague return matter before the state court. It concluded that the mother could have and should have raised a timely objection to the judge's sua sponte scheduling of the Hague matter in the state court if she really objected to proceeding there. She never notified the state court that she intended to file her Hague return petition in federal court, and she allowed the court to set in a hearing and assign the case to a specific judge. The next two cases are a reminder that a Hague Abduction Convention proceeding is not a custody lawsuit. The First Circuit issued an opinion in the case of De Silva versus Diarettes, affirming the U.S. District Court's order to return the minor child to Brazil. The First Circuit remanded the case, however, for the U.S. District Court to reword its return order. The U.S. District Court's order read, on January 2nd, ACA shall travel to Brazil to reside in the care and custody of the petitioner, Nelio Nelson Gomes de Silva. Any further proceedings regarding ACA's custodial arrangements shall be conducted by the appropriate Brazilian court under Brazilian law. The First Circuit determined that the language could be read to determine custody of ACA, and this was not permitted under the treaty. So compare that to the case of Radu versus Sean. On September 16th, the U.S. District Court for the District of Arizona returned their children to the habitual residence of Germany. In that case, the respondent mother conceded that the removal of the children from Germany in June of 2019 was wrongful. The court concluded it would be a grave risk of psychological harm to return the children to the father's custody, but that it could be mitigated by returning them to Germany in the mother's custody until a German custody determination could be rendered. So the court specifically ordered, to prevent a grave risk of psychological harm, Sean shall retain temporary custody and care of the children until a custody determination can be made by a German court of competent jurisdiction. Therefore, the court granted the petition and ordered the children returned. It indicated it would hold a further hearing if either party requested logistics on how to return the children. And as a note from myself, the opinion does not go into whether the court's order, which granted temporary custody, would even be enforceable in Germany. It didn't elaborate on what authority the court had for actually granting a temporary custody order in a Hague abduction suit. And it also didn't say whether or not the mother was willing to return to Germany with the children. So finally, away from the Hague abduction suits, which are the bulk of all of these cases every year, we're looking at international custody, and specifically in the United States, the Uniform Child Custody Jurisdiction and Enforcement Act. The Maryland Court of Special Appeals, the Intermediate Appellate Court, issued an unreported opinion in the case of Olorindi versus Coretti on August 20th. In the opinion, the court examined subject matter jurisdiction and whether Maryland was the home state of the party's children, so Maryland could issue its initial child custody order. The trial court concluded it was the home state. The appellate court agreed. The parents and their 4 children actually began residing in Maryland in 1999, but in 2009 or 2010, the father returned to Nigeria, but he would travel to Maryland for months at a time. On August 2nd of 2016, he filed for divorce and custody in Maryland, but in his pleading, he claimed that the 2 unemancipated children resided with him in Nigeria since 2015. The mother answered and alleged that the children were only in Nigeria with their father by force. She countered for divorce and custody. The court ultimately granted her primary residential custody and the parties' joint legal custody. The mother was never able to retrieve the children from Nigeria. In 2019, the father then came back to Maryland and sought to vacate the original custody order, claiming that the court never had jurisdiction pursuant to the UCCJEA as it was not the children's home state. The trial judge disagreed, indicating that the children had resided in Maryland for sufficient time and their actual presence in Nigeria was not by agreement. It was because he had refused to return them to the mother's care so she could bring them back to Maryland. The home state analysis in this case revolves around whether the children's presence in Nigeria is a temporary absence from their home state. In determining whether the time in Nigeria, albeit really lengthy in this case, is a temporary absence, the Maryland court examined all circumstances, duration, the party's intention as to whether it was temporary or permanent, and any other relevant factor. And in this particular case, the court felt that the reason for the children's absence was far more important than the duration of that absence when determining temporary absence. Now for modification, the Appellate Division of Superior Court of New Jersey in the case of Begum versus Palasami involves a multi-jurisdictional family and a New Jersey custody order. The parents had reached an agreement to share joint legal custody of their daughter and to permit her to relocate to Singapore with the mother. The father would continue having access to her in Singapore and in the United States. The agreement was incorporated into a New Jersey court order, so the initial child custody determination. The parties returned to New Jersey and their courts not long after this order because the child's mother sought to obtain Singaporean citizenship for the child. The judge ultimately agreed that the child should be a dual national. And when they amended the original custody order, they also required that the parties domesticate that New Jersey order in Singapore as a precondition to the child securing citizenship in Singapore. The couple continued litigating in New Jersey, and at some point, the plaintiff mother, through counsel, explained that despite her best efforts, the Singapore court refused to domesticate the New Jersey order because the court order used different words and nomenclature than what is used to in Singapore. The Singapore judge was actually willing to translate the New Jersey language into equivalent language under Singaporean law, but the father refused to alter the New Jersey court's language. The family saga is really indicative of the difficulties of mirroring US custody orders overseas. And it's just a reminder that clients should retain competent legal counsel in both jurisdictions early in their lawsuit. A Singaporean lawyer would have been invaluable in helping craft the language for the New Jersey custody agreement and subsequent custody order so that there would have been more likelihood of it being mirrored at a future date, and then would have advised on the process of mirroring if that was even possible in Singapore. They could have also advised on modification jurisdiction. Even though the New Jersey court has continuing exclusive jurisdiction over its custody matter, not all countries will respect that US concept of continuing exclusive jurisdiction. And once a child has relocated, the other country may actually modify the order, despite the US feeling that it can also modify its original order. So then we come to registration and enforcement, which actually is easier coming this direction into the United States because of the UCCJEA. A parent can obtain a child custody order from a foreign country in substantial conformity with jurisdictional provisions of the UCCJEA, and that child custody order may then be registered in a US state so it can be enforced. In the case of Hamdan versus Fratik, the Court of Appeals of North Carolina vacated its trial court trial court's registration of an order, which was obtained from a Sharia court of Jerusalem by a father after the party's children were moved from Ramallah to North Carolina. The father failed to meet the stringent requirements of the UCCJEA of what paperwork he needed to file in North Carolina to seek the registration of the Sharia custody order. And more specifically, he did not provide a certified copy of the custody order. To register an out-of-state child custody determination, one must file with the court a document requesting that registration, 2 copies, one which must be certified or of the order to be registered, and a statement under penalty of perjury that the order was not modified, and provide the names and addresses of the person seeking registration and any person who has been given custody or visitation under the order that is being registered. The court defined a certified copy by its plain meaning, saying it required a designation that it is a true copy by an officer who has the original document. The father never provided such a copy. Because the father did not meet the requirements, the court was divested of its subject matter jurisdiction, and the registration of the orders and their subsequent enforcement were vacated. Now to a relocation issue. In an unpublished opinion of In re Marriage of Inouye, the Court of Appeal of the State of California affirmed a mother's request to relocate her child to Japan. Both parents were born and raised in Japan and met and married in the United States. Their son was born in the US. In November of 2016, the mother requested permission to relocate the child to Tokyo. She argued that her residence in Japan was the only option for her to become self-supporting, and that both parents' families would be a support system for her and the child in Japan. The respondent father argued against the relocation. He raised concerns that any California custody order would not be enforceable in Japan. He said that joint custody is not a recognized custodial arrangement in Japan, and he argued that the minor child would be harassed due to his American heritage, and he was not sufficiently fluent in the Japanese language. The father's appeal focused primarily on the enforceability issue. On appeal, the court concluded that the trial judge adequately addressed this issue, accepting evidence on Japanese law and procedure by affidavit. While the affidavits appeared to disagree on the enforceability issue, they did specifically agree that there was a process available in Japan to mirror the orders, specifically a conciliation process, where then the California provisions could be mirrored in a Japanese equivalent. The trial court made note of its order that the United States was the child's habitual residence. The California court order said, we have continuing exclusive jurisdiction to modify our order under the UCCJEA, but the appellate court did not actually address whether that added language would actually have any impact on a future potential Hague abduction petition, or if it would prevent Japan from later modifying this custody order. It also really did not address the enforceability issue. As you can imagine, mirroring the terms of an order and then actually being able to execute and enforce that order are 2 very distinct issues when it comes to overseas custody orders, or recognizing our orders overseas. So now we get to international marriage and divorce recognition. And this is one of the biggest sources of frustration for multi-jurisdictional litigants. When you have simultaneous divorce proceedings pending in 2 countries and there are conflicts of laws issues, there are some Hague Conference treaties related to this, none of which are in effect in the United States. So in the case of Russello versus Russello, this was a couple litigating a divorce matter in New Jersey alongside an Italian separation action. The husband first filed the non-consensual separation action in Italy first. Both parties had counsel in Italy. A year or 2 later, the wife filed a divorce action in New Jersey then, which was dismissed as a matter of comity because of the Italian suit. In 2019, the Italian court issued its separation ruling. It provided for the wife's support, but it did not divide their assets. It also, as a separation proceeding, failed to divorce them. Apparently, to divorce in Italy, you must first file and obtain a legal separation, and then you file a separate second divorce action. The New Jersey Superior Court Appellate Division overturned the New Jersey trial court's dismissal of that New Jersey divorce case because the Italian action, despite being filed first in time using Italian lawyers, did not involve substantially the same claims and legal issues. So then we go across state lines in New York. The Supreme Court of New York County addressed a multi-jurisdictional divorce suit in Fetterbush versus Shaw, setting aside a separate Hague abduction suit, which was pending between the parties. The wife filed for divorce in Thailand, and a few months later, the husband then filed for divorce in New York, and he refused to participate in the Thai suit. The couple had married in Thailand, signed a Thai prenuptial agreement, had lived in Thailand, had a lot of property in Thailand, and they separated while they were actually physically in Thailand vacationing. The husband asked the New Jersey court to actually enjoin the wife from proceeding in Thailand, but the court refused, recognizing the Thai proceeding as a matter of comity. The husband provided no evidence why the Thai courts would not otherwise hold a fair, fraud-free hearing, and the Thai courts had significant connections to the couple, including the fact that the wife resided there. They had a prenuptial agreement executed there, which was actually to be construed under Thai law. So while the Fetterbush-Shaw family was filing simultaneous divorce suits, so was the Vicario-Blanche family. In this case, the husband filed for divorce in Florida, but he then voluntarily dismissed the suit. He then filed a few days later in Spain. Almost immediately afterward, his wife, who's tennis star Arantxa Sanchez Vicario, filed for divorce in Florida. The husband served his divorce papers first, so that suit was actually first in time, and the Florida trial court deferred then to the Spanish proceedings on all issues except for the children, where their home state was clearly in Florida. However, on appeal, the court dove deeper and it determined that nearly all of the family's assets were in Florida, and the Spanish proceeding would actually only resolve one issue, the divorce itself. Therefore, on appeal, the Florida divorce proceeding was allowed to move forward. Finally, in Michigan, the Thamel-Sullivan family was fighting in simultaneous suits between Michigan and India. In 2018, the wife filed for a fault divorce in Michigan alleging abuse. The husband then petitioned the Indian court for restoration of his conjugal rights and asked an injunction be put in place to prevent the wife from continuing her Michigan divorce suit. The Indian court did grant the injunction, but the Michigan court refused to recognize it as a matter of comity because the wife met both the residency requirements and was permitted to proceed in Michigan even if the husband did not want a divorce. Also, no one had actually petitioned the Indian courts for a divorce, so that was not pending in their courthouse. So I recognize this is a lot of information. It was actually only a small snippet of the volume of cases that I read over the course of 2020. In fact, if you go to my lawyer resource site, you can access, there's an easily searchable function where you can search for these issues and it will bring you to all of my blog posts, which has actually over 100 legal updates just from April 2020 going forward, which tells you the volume of different international family law updates from the HAGUE Conference, the Department of State, and all the different cases that have come down through the United States last year. And I'll continue updating it through this year. So please certainly take a look at that. And I look forward to talking to you more. And there is a pre-COVID picture of me before I actually started putting on my COVID pounds. So it was really nice having everyone here. Thank you so much. And I look forward to actually seeing all of you in person again soon.